Welcome to Term Talk, a Federal Judicial Center video podcast. Each term we discuss Supreme Court cases most important to federal judges. Joining me is Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Michael McConnell, Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School, and a former circuit judge on the U.S. Court of Appeals for the 10th Circuit. Thank you both for being here to talk about the impact of Cedar Point Nursery versus Hassid on takings jurisprudence. Erwin, the court broke along ideological lines in this case and determined that a state law requiring a landowner to provide temporary and limited access to union organizers could constitute a per se physical taking under the Fifth Amendment. Can you get us started on the case, please?
Of course, the Fifth Amendment says that the government can take private property for public use, but must pay just compensation. This is applied to state and local governments through the Due Process Clause of the 14th Amendment. The Supreme Court has said there's two ways of finding a taking. One is a possessory taking, such as when the government confiscates or physically occupies property. The other is a regulatory taking, where government regulation goes too far. California law said that agricultural employers had allowed union organizers to have access to the employees 3 hours a day, 120 days a year. There were regulations with regard to this. For example, it would have to be prior to work or at lunch or after work hours. It can't be disruptive of the work. The union would have to provide notice to the employer. Two agricultural employers brought suit alleging that this requirement for union access was a taking that violated the Fifth and 14th Amendments clauses here. And the issue was before the Supreme Court was, does the California law constitute a possessory taking? And the Supreme Court 6-3 said that it does.
Michael, how did the court get there?
So the plaintiffs in this case insisted that this rule amounted to a physical, not just a regulatory taking, relying on the principle that when the government actually authorizes physical entry into a property, that violates one of the most important parts of property ownership, which is the right to exclude. And they analogize when the government gives, in this case, the union, the right to come onto property, they analogize that to a special purpose easement. The Ninth Circuit rejected that argument, mostly on the ground that the permitted occupation was episodic, that it only lasted 3 hours a day, it was only for about a third of the year, and took the position that it's only permanent, continuous takings that are that count for purposes of the Just Compensation Clause. The Supreme Court, in an opinion by Chief Justice Roberts, rejected that idea, pointing to a pretty substantial number of cases and involving such things. And one of the first is where the military were shooting its armaments over private property, tourist property. Another case where government planes came in for low landings to a nearby airport, thus disrupting the operations of the farm. A case where the government allowed the public to use a private marina. This sort of thing. None of those involve permanent, continuous occupations. They were all episodic in a sense, and indeed, in some ways, this is less episodic than some of those. So the court rejected that idea, saying that the amount of time, if brief, if episodic, goes to the amount of compensation that's due, not to whether it was a taking in the first place. The court also addressed I think probably more serious arguments having to do with the practical implications, because the opponents of the property interest here raised, a lot of sort of slippery slope arguments. If this is a taking, well, what about government inspections of businesses and so forth? And Chief Justice Roberts drew a pretty strict line about that, saying that when the government inspections are not going to be takings, this case only applies to the when the government allows private individuals to come onto someone's property for their own purposes.
Erwin, how did the dissent, however, see the case?
The dissent didn't see the case as a narrow decision. Justice Breyer wrote for the court, joined by Justices Sotomayor and Kagan. He made three basic points. First, he said, if anything, this is a regulatory taking. It's not a possessory taking. He said, this doesn't give the union organizers any property interest in the land. He said, California law doesn't give union organizers the right to exclude. He said, what it gives the organizers is temporary, not permanent access. He says, under precedent, this should be regarded as a regulation, not as an appropriation. Second, he looked at the practical implications that Michael was talking about with regard to inspections. He said, how is this different than any of the other laws that allow inspectors to come onto property? Now, Chief Justice Roberts, as Michael said, argued that those are different because there the government is conditioning, say, the ability to run a business on allowing the inspectors to have access. Justice Breyer said, here it's conditioning the ability to run a business on access for the benefit of union peace and allowing union organizing. And third, Justice Breyer addressed the issue of remedy. He said the takings clause allows the government to take private property, but it has to pay just compensation. He said the remedy here should be money. It shouldn't be an injunction, which is what the plaintiffs were seeking.
Michael, what are the broader implications of the court's decision?
The doctrinal analysis in the case puts almost an exclamation point on some 15 years of jurisprudence in this area, in which takings clause jurisprudence, I think, has been transformed quite substantially. Things got very confused in the beginning part of the 20th century with a case called Pennsylvania Coal against McConnell, which introduced this idea of regulatory takings, which are really use restrictions. They're not takings at all. The government has no benefit from the land. It just prevents the property owner from doing something, usually a noxious use. But once this idea that regulations that go too far can be takings, that it's such a broad concept that then in the 1970s, the court tried to rein it in in the Penn Central case with this nebulous four-part test that is almost impossible for plaintiffs to satisfy. But a lot of lower courts, tended to be somewhat confused, and so they thought that lots of forms of regulation, even if they actually involved physical occupation of one sort or another, were subject to this nebulous four-part test. And I think Robert's opinion makes it quite clear that there is a narrow but important category of physical takings that are not subject to the Penn Central test, and that those are defined by the question of whether there has been either a taking of title or an actual physical occupation by someone with the permission of the government. Those cases are going to lead to compensation. And I think the nebulous the regulation goes too far type claims are, who knows, but I think they're now on the road to oblivion.
Erwin, what's your take? What are the implications?
I agree with Michael that I think this reflects a court that the conservative majority wants to have much more protection of property rights under the takings clause. But I disagree with Michael in not seeing this case as leading to a lot of other litigation. I think it will, and let me give two things that I think are going to be litigated. First, what about other laws that allow private inspectors, like utility companies, or government inspectors access to the property? I don't think it's going to matter whether it's a private inspector or a government inspector. It's the law that requires allowing access. How is that really different than this case? And second, there's the question of what does just compensation require in this instance? That's what the takings clause is about, requiring the government pay when it takes property. But how is that to be measured in situations like this? And I think both those questions are very much litigated in the federal courts in the future.
Erwin, Michael, it has been a pleasure talking to you today. Thank you for joining us.
Thank you.
Thanks a lot.